Getting beat up by spreadsheets in your brewery? Don't let those dumb pivot tables bully you around. Get rid of the spreadsheets and the other clunky brewery software and get Ollie, the smart and affordable way to manage your brewery. Learn more at getollie.com.
Hey everybody, John Szymankiewicz here with Beer Law Center. Super glad y'all are with us today. I'm up for talking about buying and selling breweries, pitfalls, and what to know as you kind of approach it from either side. First, I want to say thank you to Ollie and Tapwise for being presenting sponsors of this fall's virtual conference. Great folks to work with. I've worked with both of those folks, Ollie and Tapwise. Supporting the industry and so forth. So absolutely reach out to them if you have any questions, either on the marketing side or on the, as you saw, the if you are being beat up by pivot tables. That was a great commercial. So we're going to talk about buying and selling brewery, pitfalls to avoid, and sort of maybe some horror stories if we have enough time to get to them. Obviously, if you have questions, concerns, or want to hear more, make sure and put it in the chat. I'll try and watch that and answer questions as we go along. I'm going to try and answer questions as we go along. I'm a pretty informal speaker, so it's not like, oh, wait till the end. So if you see something or hear something that you got a question about, stick it in the chat. I'll try and get to it as we go along. So by way of introduction, where's it? There we are. There's my slide. So quick little bit about me, and then we're going to talk mostly about planning. Planning is going to be your best friend if you are either buying or selling. And I mean this with all the love in the world. Sometimes brewers aren't the best at planning, but we're going to talk about why that's important, what you specifically have to look at and look for. And then we're going to talk about how the mechanics of the transaction actually work. What are the pieces? How do you go from point A to point B, or from A to Z, all the way through purchasing or selling a brewery? And then lastly, we're going to talk about some post-closing stuff, right? After you have the keys in hand, now what? What's the rest of this? Either as a seller, how do you make sure everything is cleaned up? Or as a buyer, what else do I need to think about? What else do I need to be working on through this process? Okay. So real quickly, a little bit about me. I am a lawyer as Career 2.0. My former life was as a chemical engineer. I still have my PE license, which is kind of weird because I don't do that work anymore. This slide's a couple years old, so that 20 plus years as a home brewer, that's actually over 25 now. It's one of those, like, I've been saying 20 years, but I've been saying 20 years for like 5 years now. So, and then I've been working exclusively with the craft beverage industry, breweries, wineries, and distilleries, as well as alcohol retailers for going on 15 years at this point. I am a BJCP Certified Beer Judge, WSET Level 2 in wine and in beer. That's an addition since this came out. And nearest I can tell, I am the only Certified Cicerone alcohol attorney in the United States. Lucky me. Beer Law Center, just about us, we are a small firm. Normally when it's, hey, stuff needs to get done at Beer Law Center. Oh, it's just me. It's just me. Never mind. But no, that's not entirely true. We have a small staff here of paralegal and a couple other support folks, but we are very niche. And so if you need to talk to a lawyer at Beer Law Center, guess what? It's me, right? So without further ado, let's dive into sort of the rest of this stuff. First pitfall, and back to planning, right? I've gotten calls multiple times from somebody saying, I need to sell, I'm ready to sell my brewery. I need a purchase agreement. I'm ready to sell it. It's October 5th right now. We'd like to close on the 15th. I said, no, you don't. No, just no. It's you don't want to do that, whether you're the buyer or the seller, right? If you think you can do that in a matter of a few days, well, you probably don't understand the situation, right? Because buying and selling an alcohol business is not like buying and selling a dry cleaners or a hair salon or something else, or even a restaurant for that matter. there are more pieces involved and a lot of things you need to think about and think through all the implications. One of the ones you'll see on the slide there, it says, don't underestimate the issue of the lease or the landlord. Can't tell you how many times I've seen a closing delayed because the landlord, hadn't signed the lease assignment. If the lease ain't in your name, you can't apply to your license changes, right? Whether that's federal or state. Or the landlord hasn't signed the lease assignment or isn't willing to sign a lease assignment. They don't have to in some cases. They want to negotiate a new lease. Well, maybe that's not the best thing for you as the buyer or the seller for that matter. And this is going to come back to something, this is going to lead to something we're going to come back to later, which is what about after closing? Because one of the main concerns I've got, and things, again, you need to think about, here's one for, this failure to plan piece. That lease, because I assume most brewery owners, you're renting, you don't own the piece of property. If you do, great, sell that separately, right? Keep the piece of property, sell the brewery and lease the property to the new brewery owners. Or if you want to package it all together, that's great. The real value is probably in the property then rather than in the brewery. Anyway, assuming you're leasing, I have not seen a lease in the last 14 years that didn't have a personal guarantee associated with it. So if you own a brewery and you're leasing the space, I'm guessing you've got a personal guarantee on that. So the very first question you've got, if you are selling, is, okay, what happens with the lease? And unfortunately, I've seen landlords on both sides of this where, one landlord's like, yep, that's fine, cool, we'll assign the lease to your buyer, not a problem. I just want them to do a personal guarantee and they can step into your shoes, everything moves on, it's all good. I have seen other landlords that say, okay, you want to sign this lease, great, but you still have to keep your personal guarantee on this. Hold on, wait a minute. One of the main reasons for getting out of this, if I want to sell my brewery, is to not have that liability hanging over my head. If you're still stuck on that lease, that's a real concern. And that will probably affect, because it affects your risk in this, both during and after the sale. That may affect what you're willing to do or how much you're willing to pay. Same thing on the buyer side. If the landlord is requiring a personal guarantee that either you can't do or won't do, or yours isn't enough, and you need additional personal guarantees on there, if they don't want to let the previous owner off of that lease, you've got to factor that in. Because, for example, if I'm selling my brewery and I find out I've still got to be on the lease, well, wait a minute, that's different. What I was going to sell to you for $250,000, that just went up, because that, if you don't do well in the next couple of years, I still have to pay that lease. That's not cool. So as early as you possibly can, start working with the landlords and make sure that your lease isn't going to be a problem. Okay. So when we talk about these planning issues, I just talked about the lease as one of those. Oftentimes there's a question of not having enough time, not understanding the mechanics. How is this actually going to work? And then more rarely, but still happens significantly, it's just not understanding the business, right? Somebody who is new to the alcohol business comes in, buys a brewery or wants to buy a brewery. Sorry, I'm adjusting my fan over there. Wants to buy a brewery, but they don't understand the issues here. So for example, I worked with a client, this is about 3 years ago, that bought a brewery. I was representing the buyer, and we got them, the assets were sold. They take over the business. We got them licensed. I'm like, okay, you got it. Here's your license. Here's what you need to do. Here's all these pieces. You're good to go, right? Yep. I said, okay, ask if you don't understand anything. Okay. And then I don't hear from them for like a year or so. About a year after that, I get a call. They said, hey, we've got this issue with the Department of Revenue. I said, okay, what is it? We got this letter, and it says we haven't filed our excise tax returns. What does that mean? What do you mean, what does that mean? That's literally your job, is to make alcohol and pay income excise tax. So there is that other concern about not understanding the business. And if you are in that position, if you are somebody new to the business, new to the industry, make sure you've got a mentor in this process, not just a lawyer or a CPA or those outside service organizations. Make sure you've either got a team that knows this stuff, or you've got a mentor that can say, oh, by the way, did you do this? Did you do this? Did you do this? All those other pieces, because the real danger there is not knowing what you don't know. Okay. So if we're talking about planning, I would suggest from the time you agree on a purchase price to the time you close on that deal, and again, this is a little bit like buying a house, right? You go, you look at the stuff, you kick the tires, you walk around, you get shown the house, then you sign a contract, and the contract is not the purchase, right? Just like when you buy a house, the contract is a promise to purchase, right? So a purchase agreement for buying a brewery is not the purchase. It's the promise to purchase, right? So from the time you agree on a price to get your purchase agreement, which lays down the terms of that purchase, until you close, I would plan on at least 60 days. More than that if you are looking at financing, right? And when I talk about financing, the big one there is whether it's SBA or a bank. Loan officers will tell you, oh yeah, 30, 45 days, no problem. I have never seen an SBA bank loan and close in less than 90 days, right? So keep that in mind and make sure that if you're going to finance this, you know how much sorry about that. Minor tweak to technical difficulties, but we've got it taken care of there. Sorry again. Anyway, so what I was saying is once you have that purchase agreement, actually before you have a purchase agreement, figure out your financing. How are you going to pay for this thing, right? Because that will drive a big part of your timeline. Plan time for due diligence. So what the hell is due diligence? Due diligence, just like when I'm going to keep using this analogy, when you buy a house, you sign the contract, and then you can go hire a home inspector to come inspect the house, right? You can do a title search. You can make sure that the person selling it to you actually owns it, all those kind of things. That's your due diligence period, right? Look into the finances of the company, understand the employees, understand if there are any liens out there. Do they actually own the stuff they're selling to you, right? Are there liens on the equipment? Is there financing there? All that sort of stuff. And then you need to plan in some time for, bumps in the road, stuff you don't know that could come up. Great example I had of that. This was 4 years ago. There was a majority owner was representing the seller in this transaction. Buyer's like, yep, this is all great. We go to do the purchase agreement, send the purchase agreement over to the seller, and we knew that there was a minority owner in the business that we were buying the brewery from. What we didn't know is that they didn't get along with and had not talked to the majority owner in some time. And so when majority owner says, hey, I've got this purchase agreement, these folks are ready to buy, it was a surprise to that minority owner. So suffice it to say that set us back a few months in conversations and negotiations, because my client thought everything was on track. The minority partner knew all about this. Like, they didn't, and unfortunately didn't find out about that until, again, the rubber hits the road when we try and finalize that purchase agreement. So plan for things that may not go exactly to plan, right? Things sometimes for variances and expectations. All right, next slide. Guess what? More on planning. All right, so let's dive in a little bit deeper to this. First thing I always ask folks, whether I'm representing the buyer or the seller, what are you buying or what are you selling here, right? And there's two major distinctions. You can have an asset sale, right, or a company sale. Am I buying the assets or am I buying the company? And I walked through this with one client the other day, and I said, okay, so what kind of sale is this? This is an asset and business sale. I said, no. It's one or the other. You're either buying the business or you're buying the assets. You can't buy the assets and the business, right? If you buy the business, you buy the LLC or the corporation, you get all the assets with it. Those assets belong to that company. If you buy just the assets, you get everything that that company owns except all the liability that they owned previously, right? And that's that next line item there, liability and tax issues. So if I am representing the buyer, I want you to buy the assets, right? And the issue there is when you buy the assets, you get to buy all the stuff that looks like that brewery, right? Obviously the brew house, tanks, inventory, trademarks, product names, recipes, the look and feel, the trade names, all the artwork, everything that makes it look like them. Those are all assets. And I challenge somebody, because I've done this probably 15 times, the company changes, right? One company buys the assets of another company, that company goes out, and it looks completely transparent to the consumer because those assets are what makes up the business that people recognize. On the other hand, behind that, the company that owns those assets, the business, the LLC or corporation, that's the entity that owns those assets, right? So let's look at it this way. I'm working with a client now, and I'm talking to the buyers and the sellers, and the seller says, yep, I want to sell the business. Cool. And I'm going to owner finance the sale. I said, okay, that's great. We can figure that out. However, it looks like the owner of this business is not you personally, it's another company. Yes. All right, so that company has to sell the business, not you personally. He said, with that, I'm the only member in that company. I'm the only owner of that company. I said, yes, but you just own the company. The company owns this other company. Okay, I'm not making a whole lot of sense there. Let me back up and do this a little bit differently. Company is trying to sell the assets to, John's Brewery is buying the assets of Bill's Brewery. And Bill says, I'm going to finance the sale. So that means that I'm going to give you John's Brewery the assets, and John's Brewery is going to pay me every month for this. And so the answer there is, well, yes, but Bill, you don't own that brewery. Bill's Brewery LLC owns that brewery. That Bill's Brewery LLC owns all those assets. So they're the ones who have to finance that. John's Brewery needs to pay Bill's Brewery LLC for that owner financing. Now, Bill's Brewery LLC can transfer that note, that debt over to Bill personally, but I can't pay Bill personally for something I bought from the company because Bill doesn't own those assets. The company owns those assets. So it's real important, especially if you're thinking about owner financing, who's buying what from whom, and are we buying the business or are we buying the assets? My concern, like I mentioned, if I'm representing the buyer, I want you to buy the assets. And the reason for that is if you just buy the assets, you cut off all the previous liability that business may have racked up. Say, John, what the hell does that mean? All right, so let's picture another example. I'm going to go buy Bill's Brewery LLC. I'm going to go buy Bill's Brewery LLC. And I look at all the employees. Yep, everything looks great. They look like they're all performing really well. I'm going to keep all those employees after I buy Bill's Brewery LLC. But what happens if, like last year, before I even knew about it, one of the supervisors, like the head brewer or somebody, sexually harassed a coworker? Okay, that's not good, clearly. But that liability for that sexual harassment, at least in North Carolina, has like a 3-year statute of limitations, meaning they could wait. That happened a year ago. They could wait another 2 years before they even file a lawsuit about it. In the meantime, I've bought Bill's Brewery LLC, and Bill is off. He's moved to the Caribbean somewhere. He's gone. He's done. Well, the company is still liable for that because it's still the same company, right? So there are other issues like that. What about back taxes, employee withholding, old debts? Okay, if you know all the stuff that's out there and you can make an intelligent discussion or decision about taking on those business liabilities, that's fine. The thing that concerns me is a lot of times we won't even know what those liabilities are. They're latent. We wouldn't find out about it until something else happens. Maybe Bill doesn't even know about it, right? That sexual harassment, that maybe that coworker never came forward until 2 years later, right? So if I'm representing the buyer, I want to cut off that liability and say, okay, from this point forward, it's buyer's LLC. From that point backwards, it's seller's LLC. So if it happened back here, hey, Bill, you got to deal with that. That was your company. You got to handle that problem. If it happened after I purchased it, after the buyer bought it, okay, now it's buyer's problem, right? On the other hand, if I'm representing the seller, I want you to sell the company for exactly the same reason. After this is over, Bill, go to your island in the Caribbean, go to your beach house. I don't care, because you're done. You're out of it. You're completely finished. The company is no longer yours. It's not your problem anymore. That belongs now to the new buyer. So think about what you're doing here and think about what you're buying and from whom again, and which one is worth more to you, right? So again, if I'm the seller in this case, I want to sell the company, not the assets. And the buyer's like, no, I just want the assets. Okay, well, if I have to keep all this latent liability that I don't even know all that's there, maybe if I'm going to hold on to that liability, I'm going to charge you more for those assets, right? Because I'm still stuck with that liability. Maybe I'll give you a break on it if you take everything off my hands, right? Same idea, right? We talked about financing in terms of planning. This is another big one, pitfall number 3. How are you going to pay for this, right? If it's a bank financing or SBA, plan in time to close, because it can take a while. The other part of that is the SBA, and most banks will still ask for a personal guarantee. Last I heard, depending on the loan program you're using, they're looking for anybody who owns 20 or 25% or more of the company to sign a personal guarantee. Now, if you've got business partners, there may be one or more of those that are like, no, I'm not signing a personal guarantee, right? Especially if it's somebody who has maybe a lot of discretionary income or a lot of assets. Like, no, I'm not going to sign a personal guarantee. If this business fails, I've lost everything I'm going to put into this, or I'm going to put in everything I can afford to lose. That's it. I'm not doing a personal guarantee. So that means you need to probably adjust that person's ownership down to get them below whatever threshold that needs to be. So be careful. Be careful and think through those issues before they come up. Are there loans already on the business? If you have an attorney help you, they should be doing this. Even if they do or don't, you probably want to do this on your own as part of your due diligence. And that is specifically go do a lien search on those assets or that company, no matter which one you're buying. Do a lien search. You can typically do that through the North Carolina, through the Secretary of State for your state. It's called a UCC-1. That's the name of the form that the financing people have to file with the Secretary of State to put the world on notice that they have a claim on or a lien on assets at a particular location. So you would do a UCC-1 search for the name of the company, the name of the individuals, and probably even the address that you're looking at to figure out whether or not there are any liens on anything there. I had this happen with a client 2 years ago where they had 2 locations, and one location was entirely debt-free. The other location had a bunch of debts on it. And they said, we're going to sell the debt-free location. And I said, okay, great. Do you have any liens on it? No, absolutely not. Okay, I'm going to do, I was representing the seller at that point. I said, okay, I'm going to do a lien check just to be sure. And I'll be damned, under that location that had debts, the lien language said any assets of the company, regardless of where they're located. So that meant not just that location, that meant that other location too. And now all of a sudden, everything came to a screeching halt, because what that meant was they couldn't sell that debt-free location until they paid off the debts of that other location, or that debted location, which is what they didn't want to do. So everything came to a screeching halt. So do that lien search, know whether or not they actually have the title to be able to sell you what they're trying to sell you, or if there's something still outstanding, right? So for example, it might get into this situation like, yeah, that pump over there is one of the assets we're selling you. And then in your UCC search, it says that pump is still under a lease. Oh, wait a minute. So am I taking over that lease? Do we have to clear that with the equipment financing company? Or did you just mistakenly think that was yours and now you're going to keep that or return it? Work through those things and look at those financing pieces. Next question, how are you organized as a company, right? Are you an LLC? Are you a corporation? And generally, I'm not too concerned about that as long as there is some sort of limited liability structure there, again, corporation or an LLC. But what may be what may be something to consider here is who has the right to speak for that company. So just like the example I gave earlier, where there was a majority owner who was looking to sell everything and hadn't told their minority owner, well, what's their authority? Could that person have done that without telling that minority owner and drag them along? Well, I don't know what their operating agreement says, right? That's one of the next questions. And that same question goes for you as a buyer, right? Whether you're buying or selling, do you have the authority to do this on your own? Do you have to get a member or shareholder approval to empower you to sign this document or these documents on behalf of the company, to bind the company for these leases and financing and all that other stuff, and just the purchase in general? So that company organization and who has the authority to bind the company can be really important there. Okay. And this is another one. Pitfall number 5 I've got listed here. Okay, so we signed a purchase agreement. We got 60, maybe 90 days, depending on financing, before this is going to close and before I take over the running of this business, or before the buyer takes over the business. How do we run the business between there? And I've seen far too many. It's like, oh, well, you just keep doing what you're doing. No, time out. That is not what you want to have happen there. You need to have specific rules about what can and can't happen between the time that is signed and the time that closing happens. Because if it's just normal operations, well, what you think of as normal operations may not be what John thinks of as normal operations, right? So what if I'm the seller and the buyer says, yeah, just keep doing what you're doing. Cool. Well, I know, oh gosh, I need to hire 2 bartenders. I'll go ahead and hire them. And hell, I'll hire them at $25 an hour. Now they're that person's problem after I leave. Wait a minute. You needed to hire 2 people and you didn't tell me about that, and I'm buying the business from you? We should have had a conversation there. Those are the kind of things you need to identify all along the way. Are they allowed to hire people? Are they allowed to fire people? Should there be consultation between the buyer and seller during, for major issues like that? What if a piece of equipment breaks? What happens then? I need to replace that. But maybe if I'm the seller, I don't really want to pay to replace that pump if it's being sold to somebody else in 2 weeks, right? There should be conversations and limits about, like, okay, if it's below this threshold, I pick a number, I typically use like $10,000. If it's less than $10,000, nope, seller, you got to fix that crap. That you're giving us good assets, you're giving us stuff that was working when we bought it, do that. If it's over a certain number, maybe $10,000, then we have a conversation. And if you don't want to fix it, seller, maybe the buyer can walk away at that point, because that's a significant difference from what they were planning on buying. Depending on where you are, another one might be weather issues, right? So what happens if a hurricane comes through and floods your brewery, right? Okay, and is the purchase agreement still in force? Can I force that buyer to still buy the brewery, even though it's been closed for 4 weeks now because of flooding? And by the way, I'm the brewery owner. I pocket the cash and bail. And this buyer's stuck with flooded assets. Half the brew house is electrical and doesn't work anymore. Not my problem. I'm out. You've got to lay out what are those rules, what are the expectations, and what's enforceable. If you leave too much if you don't address those issues, you're leaving them to chance, and you could end up losing your shirt in doing that. All right, I'm going to try and move on from planning. I think my next slide is not planning. Yes, it's more about the mechanics, and that's good because we're about halfway, and I am almost halfway through the slide, so we're on time. Mechanics. So how does this actually work, right? When you buy an alcohol business, a brewery, first, the buyer and seller need to get together, right? Whether it's I'm a seller and I'm using a business broker to find me a buyer, whether I'm a buyer and I'm just trolling websites, looking at equipment auctions or something like that. Somehow I make contact, right? We look at each other. We say, yeah, I think this could work. We have some kind of discussions about ballpark prices. I get a tour of the facility. As the seller, I'm pretty confident this dude has the money that's going to be required, or I'm willing to finance. And I think he's got good credit, or maybe there's a personal guarantee I think we can get. So we negotiate, right? We think we've got something we can work with, and we start negotiating about the terms. And that should lead to a letter of intent. As an attorney, I really don't care about that letter of intent so long as it is a non-binding letter of intent. What does that mean? That means typically in like the first paragraph, it says this is a non-binding letter of intent. And all that should do is lay out the general terms that you're looking for in the transaction. Things like purchase price, how is it going to be paid, what assets are involved, or what, whether it's the company or the assets or the ownership interest, who the parties are, what the big stuff you can think about, maybe a non-compete agreement, so that, if I'm selling John's Brewery, I can't just go open Jack's Brewery 2 doors down from the one I just sold, in a year. Maybe I've got to get away for a little bit of time. Non-compete agreements. Maybe I've seen this happen several times, is the seller actually owns the brewery and the property it's on. Well, they're not selling the property. They want to be a landlord and sell the brewery. Okay, so that letter of intent includes a lease, and it's got to be a lease on these terms. And maybe that includes, hey, if your seller is the landlord as well, maybe that includes a first right of refusal if they ever want to sell the building or the property, right? Those big items, big terms need to go into that letter of intent, because that is a good way to show, yes, this is what we have decided at this point in time. Great. That then gets handed off to some doofus like me, right? Or if you want to do it yourselves, a purchase agreement. If you are going to do this yourself and don't rely on a lawyer, go look at purchase agreement examples. Go look at alcohol producer purchase agreement examples, because they're different, right? Things like non-transferable licenses. Federal licenses are non-transferable. Some state licenses are transferable. Some are not. Whether you're buying the company or buying the assets is 2 different licensing parts. How you actually run the business from the time you purchase until your permit or your license is approved may change from state to state. Then there's also, of course, also the trademark labeling, product registration, all that other stuff that's out there specific to the alcohol side. So if you are going to try and do that yourself, make sure you're looking at examples of purchase agreements for an alcohol seller, an alcohol producer. Do not rely on ChatGPT to say, hey, ChatGPT, give me a purchase agreement for selling my brewery. Even if you just hire some doofus knuckle dragger like me to just review it, get some legal advice on this, because that purchase agreement can make or break you. And there's a lot of pieces in there that you want to make sure are very clear. Warranties by both the buyer and the seller, disclaimers, indemnifications, transfers of rights, all kinds of stuff that's really, really important. So even if you try and do it yourself, at least pay somebody to review it if you need to, because that purchase agreement drives the rest of the transaction. That purchase agreement identifies when the due diligence period is. Now, due diligence is, like I said from the slide earlier, let's say we've got 60 days between signing that purchase agreement and closing. The first 30 days is your due diligence period. That due diligence period, you get to, look at the books of the business, maybe get an independent audit, check on their leases, do that UCC1 search I talked about. You're going to review the personnel files. Oh my God, this person has had a history of sexual harassment. I'm not keeping them. They got to go. Identify all those potential risks, by looking at what the company's records, right? And you can do that whether it's a business sale or an asset sale, okay? That's your due diligence period. And in that period, specifically for due diligence, and this should be spelled out in that purchase agreement, if you find something that is a make or break problem during due diligence, you can cancel the agreement during due diligence without penalty, right? You typically at that point, if you put a deposit down during due diligence, if you find something and you walk away, you get that deposit back. Now, sometimes you will see sellers require a due diligence sum. And I've got a client now where I'm working on this where they said, okay, give me $1,000 for due diligence and $4,000 for a deposit. So it's a total of $5,000. If you walk away or if the buyer walks away during due diligence, the seller keeps that $1,000 but has to give back the other $4,000, right? So deposits you should get back entirely. Earnest money or due diligence money, maybe not, depending on how that's drafted, but that should be spelled out in that purchase agreement. That's also during your due diligence. Well, I'll go back to due diligence first. Due diligence is from maybe say that first 30 days. It can be as big or as small as you want. Be very careful making it too small, because if you let's say, oh, I only need 3 days to do due diligence, and you don't look at everything, you can't come back later and say, I didn't know, right? Because you had an opportunity, you negotiated for that 3-day period. If you didn't take advantage of that, that's unfortunate. Because after due diligence ends and you back out or you withdraw from the agreement, now that deposit's gone. Either that deposit's gone or they can actually force you to go through with the transaction at that point, right? It is an enforceable agreement. That due diligence period is your time to back out because you found out something you didn't know previously. After that, it's enforceable. And it's going to be painful to separate. So that period of time, you got due diligence and then some period after due diligence before closing. That's also your period of time to get your financing, so you make sure you have your money in the bank on closing day, right? So again, that may be a situation where in the purchase agreement it says, oh, we're going to close in 60 days from the signing on this. And then come like day 55, you figure out financing isn't going to be done for another 30 days. Now we need to amend that purchase agreement to give there another 30 days or 35 days or 45 days to get that financing, right? Schedule that out and know that, okay, on an express written approval by both parties, the closing date can be extended for X days, right? We can do that sort of stuff. But again, you've got a purchase agreement, you need to follow it. You stop following it, it stops becoming enforceable. All right, so purchase agreement, due diligence, financing, then you have the closing. Closing is the actual purchase. Where the purchase agreement is the promise to purchase later. Closing is purchase. That's when, if I'm the buyer, I give the seller the money. If I'm the seller, that's when I give them the keys and the security passwords and, tell them all give them access to all the social media stuff and security systems, all that sort of stuff. That's what happens at closing, as well as signing a whole bunch of paperwork, right? Again, just like buying a house. Think about, I always tell clients to think about, you are spending probably hundreds of thousands of dollars on this. You can't buy a house without getting writer's cramp from signing so much. This is not that much different, right? So you're going to sign the purchase agreement, and then at closing, you're probably going to sign a bill of sale. You're going to sign a closing statement. You're going to sign some sort of release, probably maybe some financing paperwork, especially if you've got SBA financing associated with this. You're probably going to sign some sort of release. You may have to sign, your lease assignment from the landlord. There's got to be lots of stuff to sign there, right? So that's when all those pieces happen, right? And then after that, that's when we have to start worrying about the post-closing issues. What happens next? How do we keep going with operations? If you're the buyer, if you're the seller, what do I need to worry about afterwards? Okay. So that's the general mechanics. I talked a little bit about this already in terms of the purchase agreement. It drives everything, specifies what's being bought, sold, and often more importantly, what isn't. Some assets don't convey, right? We're selling all the stuff in the building except that frame picture of Granny. That's mine, and that comes with me. Okay, maybe that's important, maybe it's not, but maybe that giant tractor that's been outside for 10 years, that's become the mascot of the building of the business. Well, no, that was my grandfather's tractor. I'm taking that with me. Okay, we need to talk about that, because otherwise that was, kind of included in when you said everything, right? So maybe what isn't or what doesn't convey is important there as well. Pitfall number 6 there is almost everything plays off everything else, right? And what I mean by that is that example of, well, here's a good one. It's the example around, well, the landlord doesn't want to let the previous owner off the guarantee. What in me as if I'm the seller and the landlord wants me to stay on that guarantee. Wait a minute, I didn't sign up for that. If we're gonna do that, we need to talk different about price, or you need to indemnify me with a personal guarantee to me, or you need to post a bond that's going to guarantee me. Other pieces are going to kind of fall into place. Same thing with your financing, right? In terms of, well, everybody that say owns more than 20% needs to do a personal guarantee. But I've had one client have to post their house as collateral because they didn't have enough assets without that to meet a personal guarantee, or they didn't have good credit to meet a good personal guarantee. There's a great example. Your employees, are you keeping those employees? Okay. If it's a new company and you're just buying the assets, you got to set up payroll, bank accounts, all that sort of stuff. If it's not, if it's the existing company, okay, now you have to get access to that company's payroll and bank accounts and so forth. Everything is very, very intertwined, so you have to be careful there. I've seen purchase agreements. In fact, I've got one here, one page on one side, and half of it's a graph. And they said, yeah, we can just sign this. No, that is not sufficient, right? The amount of effort that ought to go into this is proportionate to the risk. If you were buying a $4,000 pump, yeah, one-page purchase agreement is probably fine. Sorry about that, everyone. There we go. Sorry about that, everyone. My camera keeps going back and forth, and I'm having apparently some difficulties with that. Anyway, where I was going with that was, if you're paying a couple $100,000, $300,000 for this brewery, yeah, one-page agreement's not enough, right? So you have to put in more detail. Let's try that again. All right. You have to put in more, I'm sorry, everybody. You have to put in more detail about this, such as, what about things like the risk of loss? Like I said, what about flooding? What happens if, some major event, storm, catastrophe, volcano, earthquake, whatever? What about claims of others? This is one that I think is particularly interesting, because it's things like, okay, John is selling John's brewery, and John is married. Does John's wife have a claim on the brewery, right? Was that a community asset? Did she have a claim? If I'm getting divorced at the time, does she have a claim on that? And should she have to sign off on that? What happens if she comes back 2 years later and goes, hey, I never waived my claim to that, and John sold that without my permission. I'm coming back after those assets. All right, there's got to be some sort of indemnity by the seller to avoid that situation. Or I've got another client that is looking at selling, and we're kind of going through their books, and I'm looking at their operating agreement. And about 2 years ago, I see that the operating agreement changed. One day there's Bill and Johnny and Susie, and then the next operating agreement there's just Bill and Susie. What happened to Johnny? Oh, we bought out his interest. Do you have any paperwork for that? No, we just signed a new operating agreement. Okay, so what happens if he sues everybody a year from now, claiming that you never bought him out, and you just sold his part of the business without asking him? Well, but we did. Well, how do you prove that? So claims of others, if I'm the buyer, I'm worried about, can you as the seller make sure I approve or demonstrate that I am getting good title to all this? Nobody else has any claim to the stuff I'm buying. That's what I mean by claims of others. What about issues like prorated taxes, right? We only pay taxes on some things once a year, like property taxes. But if property taxes are due in November and I buy in October, do I have to pay the property taxes from the last year? Or do I only pay that month between when I bought it or from when you sold it till taxes are due? We talked about latent liabilities. Latent expenses are things like that you just haven't received the bill from yet. So maybe something that's only billed quarterly, or something that's maybe only billed annually, like taxes. What about those, right? Who's responsible for those? Well, it depend on who signed up for it, right? Or when the business or the assets were sold. What happens to the employees? That's always a big question, right? One thing that consistently gets missed in purchase agreements is a dispute resolution procedure or clause. And I've seen disputes come up after closing that now, like, well, you said I was getting this piece of, you said I was getting this pump, but when I showed up the next day, a different pump was here. I want the pump I bought, not this rusty piece of crap. And maybe an owner switched pumps or something like that, or switched a piece of equipment. Well, if you don't have a dispute resolution procedure in place, the only thing I can do, or the only thing that the aggrieved party can do, is sue about that. And as soon as the lawyers get involved, or as soon as the lawyers get involved, they're the only ones who win. So you need to have some sort of other procedure, like mediation or arbitration, that you can go to first and have get a resolution without filing a lawsuit for everything, right? Attorney's fees. If I have to go sue you to enforce this agreement because, for example, I owner financed the selling of the brewery, but you stopped paying me, and I have to go sue you to force you to pay me. Do I get attorney's fees? Do you have to pay for my attorney to do that? What are the accommodations there? And of course, warranties. And warranties is a big topic, but it's things like my license is in good standing. I'm currently authorized to conduct business in the state. The assets are all in good working order, right? Or they're all sold as is, where is, with no warranty. I promise that at closing, if I'm the seller, I'm going to give you free and clear title. I'm going to pay off all the liens. There won't be any liens attached to these assets that I'm selling you. If it's the company, I'm warranting that I've disclosed to you everything that I know could be wrong or could be a risk to the company. All those warranties, so that if something comes back different, you can point to, well, you said here something different, and what you said isn't right. You need to make it right because you gave me that warranty on that issue, right? All right. And a bunch of other stuff. That's why I say, even if you're going to try and write this stuff up yourself, even if you don't want to use a lawyer for most of the transaction, at least get some legal help on reviewing that purchase agreement. And more, so we talked about that. Then going back to the mechanics overall, we've talked a lot about these pieces already. The documents themselves drive the transaction, right? The letter of intent, non-binding purchase agreement. We just talked about that a whole bunch. Closing documents. Here are all those other things we want to or we need to sign at closing. Bill of sale, a title transfer. That's really important because, unlike cars or real estate, if I'm selling a tank to somebody or a brew house, it doesn't have a title document. So how do I know that, if I have this brew house, how can I prove that this brew house is the one that you sold me? Maybe it's got a serial number, and I say on this title transfer, I as seller transfer, brew house with this serial number, these assets, this stuff to this person on this date, right? Something that shows that that's changed hands, maybe more than just a bill of sale. Evidence of approval, right? You may have to get these things approved, like for example, a shareholder or member resolution saying, yes, we approve of this sale, and John has our authority to sign on all the paperwork to sell this. There's in some states, you can use a management agreement. Here in North Carolina, for example, from the time that the closing happens, you can sign a management agreement with the buyer so that they can continue to operate under your permit for a period of time. And then so that may be an option in your state. Get local counsel on that. Don't quote me. That is not legal advice. And then maybe a release that I always recommend, such that, okay, at the end of closing, both parties agree that each of us has done everything we promised to do. Once we walk away from here, we're all done. We've finished everything. You can't come back and say, oh, well, I didn't get this. No. We agreed. It all took place at that time. All right. So then post-closing, staying in production, pitfall number 9. In general, license are non-transferable. Some states you can. This is talking a little bit about that management agreement I just talked about that may be available in your state. What we do in North Carolina and to some extent Virginia is for example, if it's an asset sale, purchase the assets, immediately lease those back to the seller. Then the seller hires the buyer to provide labor. And as payment for the lease of equipment and the labor to run the business, the buyer gets all the profits of the business as payment. The licensee still has to pay the excise tax because it's still under their TTB permit. And this all works until the buyer's TTB or ABC permits are approved, referred to as a leaseback operations agreement or a management agreement. More on post-closing. The keys change hands, but then there's a bunch of other stuff that still has to happen. Some of this we captured in the purchase agreement, like training, transition assistance. Hey, you're going to help me do bookkeeping for a little while, or you're going to help me, train on the system, that sort of stuff, or teach my brewer to do pieces. But then you still have to transfer all the ownership of the website, social media, the utilities accounts, or set up new accounts in your own name. What about the POS, right? And all of these are true whether you are buying the assets or whether you're buying the business, right? Or whether you're buying the company. If you're buying the assets, you probably have to set up a new accounts for all these things: utilities, your supplier contract, your POS, your payroll, all that sort of stuff. If you're buying the company, great. Now you still have to get access to what was probably an individual security login for that company. Get access to that individual's electronic utilities account. Again, the website and social media, those supplier agreements, BSG and all your raw materials folks, as well as employees and payroll, all this other stuff. You need to have a post-closing plan with some sort of graduated timeline. If you don't, and you haven't banked on this, you're going to miss something. You want to have this really well thought out and really structured so you know where things are going and what to do when, and how not to get overwhelmed at the first stop, or at the, when you get to closing, how not to get overwhelmed and think, oh, I'm all done, everything's great. No, you need to take that next loop and go, okay, no, there's things that need to happen still over the next month, 2 months, or 3 months, hopefully sooner, to make sure everything is now in the name of either me as the new business owner or me as the new assets owner, right? Okay, so I think I am getting close on time now. Yes, I'm going to flip through these. Contact us. Ooh, that's the wrong QR code. Don't use that QR code because that goes to the wrong presentation. But I will have this. Well, obviously, this is on the fall virtual conference. It'll be up on YouTube to watch later on. Also, I'll put it on the website, on my website, and on the blog, beerlawcenter.com. Please contact us if you have any questions or there's anything we can do. Let's see. I don't see anything in the way of questions in the chat. So let me, I think it's 55 in right now. I'm trying to think if there's anything else I can tell you that might be entertaining or mildly humorous in the meantime. No, I can't tell you about that without violating client confidentiality and getting one of my clients in a lot of trouble. No, I can't tell you about that because that was just a really stupid thing to do. No, I can't tell you about, no, so I can't tell you anything funny other than please, 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 whether you're buying or selling, get some legal help. Even if, you don't, if some of this stuff you can absolutely do on your own. But if you mess up that purchase agreement, if you mess up that closing, that will absolutely come back to bite you in the ass later. Get some help, even if it's not me. Get some legal help to make sure you don't make mistakes when the rubber hits the road in that situation. All right. I'm going to go ahead and sign off. If you have any questions, shoot me an email at john@beerlawcenter.com. Always happy to chat. If there's anything I can do to help, let me know. Even if it's not me, I'll help you find somebody. And good luck out there and enjoy the rest of the conference, y'all. Cheers.
Thanks for watching. If you enjoyed this session, we'd love to see you in real life. We host in-person workshops across the country for craft beer professionals just like you that are held in some of the most exciting beer destinations around. These immersive events are designed to help you grow and connect with others. You'll meet peers from across the country and leave with actionable strategies for success. Connection has never been more important, and you can learn more at cbpconnects.com. Cheers. See you there.